Welcome to the Law School Toolbox podcast. Today we're talking about how to issue, spot, and exam questions so you can understand what to do on exam day. Your Law School Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the law school and early legal career experience so you'll be the best law student and lawyer you can be. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review or rating on your favorite listening app. And if you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on lawschooltoolbox.com, and we'd love to hear from you. And with that, let's get started.
Welcome back. Today we're talking about how to issue, spot an exam question by focusing on the facts, and we'll actually walk through a question with you. So, Lee, why is it so important for law students to become experts at reading the facts in these hypos?
Well, I think law students often get really obsessed with learning the rules, which is, of course, very important. But it is also important that you become very good at reading fact patterns and recognizing that every fact is important, or at least a good chunk of the facts, depending on how your professor writes an exam. And it's also important to remember that these exam questions are kind of a constructed reality. Your professors are writing these questions with an answer often in mind, and they're creating sometimes bizarre facts to trigger a very specific legal issue or response. So sometimes I think law students come to these questions thinking like, oh, that's weird, that wouldn't happen in the real world. But it doesn't really matter what would happen in the real world because this is a law exam world, and it's very different.
Right, it might be based in reality, but it is not actual reality. Think people can fly, maybe they're aliens, you never know. You just kind of have to go with it.
Yep. And so today what we wanted to do is talk through a question together. We'll review a little bit of law before we do the question, but we really wanted to start talking about, how facts can trigger legal issues for you. So when you put together an exam answer, you're really coming from the facts. The other thing I think that can happen with law students is they get so consumed by memorizing all of the law that they kind of forget that the professors don't really just want them to spit back law. They need to apply that lot of facts. So if you have memorized every single, criminal law rule around battery and assault and all these different crimes, but they don't give you any facts triggering those, they're not going to give you any points for just talking about how brilliant you are because you've memorized all these rules that aren't applicable to the exam question.
Right, or if somebody has gotten really interested in theories of criminality or the history of how criminal law has changed and you want to write a discourse on that in your exam instead of talking about what your professor actually asked you about, probably not going to end well.
Yeah. So based on our few examples here, you might think that maybe we're talking about criminal law today. Maybe.
Why is that on our mind, Lee?
I don't know. Well, let's talk through a quick review of the law that you need to know to be able to do this mock exam question. So some of this hopefully will be familiar to you. If you haven't taken criminal law or criminal procedure yet, some of it might not be, but if you've watched any sort of Law and Order, you've probably heard some of these rules before. So I think at least I like using crim for these examples because everybody has some understanding of crim law. All right. So first, let's mention the requirements for the Fifth Amendment. The Fifth Amendment is Miranda warnings, which you have probably heard or know. It's the right to remain silent, yada, yada, yada. And so you have to get a Miranda warning if you are subject to a custodial interrogation by a police officer. So it's always important to remember that it has to be a custodial interrogation, not just an interrogation. It has to be by a police officer. Then we also need to talk about the requirements around the Sixth Amendment. So once formal charges are filed against you as a defendant, you have a right to counsel during any police interrogation. I don't know, Alison, do you think there's an interrogation happening in this question, maybe?
I'm going to guess that there is.
Yeah.
And hopefully if people are listening to this, you might have caught the fact that one of these is a police interrogation and one of these is an interrogation by a police officer, which is exactly the type of distinction that people just love to test on exams.
That's true. Also, one of these, the Sixth Amendment, attaches when you have been charged and formal charges are applied. One of them is just if you're being interrogated. So these are also two very different situations. when Miranda applies and when the Sixth Amendment applies can be very different situations. So
right. And the sort of analysis we're doing right now is actually the analysis I think people need to be doing when they're learning the law, where you're really looking at, okay, where might this apply? Where would this apply? When would this apply, but this wouldn't apply? Those are the types of things that you're likely to be tested on, more than just being able to spew out that the Fifth Amendment says you get a Miranda warning if you're subject to a custodial interrogation by a police officer.
Right.
It's like, okay, how does that play out in the real world? How might you push or pull on that to make this an interesting exam question?
Yeah. And I think as you're learning that law, you need to be able to say to yourself, what's the difference between the Fifth Amendment rights versus Sixth Amendment rights? And when you're in a study group and maybe you're reviewing law, those are the kind of questions you want to be asking each other. If you don't know the difference between the Fifth and the Sixth, that's a problem.
Right. And it's so easy to gloss over these distinctions. I mean, honestly, when I read this the first time around, I didn't notice the difference. It wasn't until I got to the question and looked at the answers and the analysis and was like, oh, I don't think I really paid attention to the distinctions between these two.
Mm-hmm. Yeah. And that's the other reason why you have to practice, because oftentimes the fact patterns that you're practicing off of will help highlight these distinctions for you.
In a somewhat unpleasant way.
Oftentimes in an unpleasant way, but that's why you practice.
When you look at the answer.
Right. So at least the unpleasantness is in the privacy of your own home.
Exactly.
All right. So now we're going to move on to homicide, something that is almost always tested in every criminal law class. So we're going to start with murder, which is the unlawful killing of another human being with malice and a forethought. There are 4 theories in which you can be convicted of murder. These are the intent to kill, the intent to commit great bodily injury, having a wanton, willful disregard for human life, and the intent to commit an underlying felony that often has to be inherently dangerous, also known as felony murder. You can mitigate murder because you can claim self-defense, which is an honest and reasonable belief that a victim is about to kill or inflict great bodily harm on the defendant. We also have voluntary manslaughter, which is different than murder. Voluntary manslaughter, as it relates to the imperfect self-defense argument, is when one has an honest and unreasonable belief that a victim is about to kill or inflict great bodily harm, and this downgrades murder to manslaughter. So again, with our discussion of, hey, you better know the difference between things, it's important to know what's the difference between self-defense and imperfect self-defense. One, they're both an honest belief, but one is reasonable and one is not reasonable. And that's an important distinction.
Imperfect self-defense doesn't mean that you actually didn't defend yourself.
That's true, or you missed.
As you might think from the name.
That's true. It's not like I shot but missed, so it was imperfect self-defense. That's not how it works.
Yeah, that's not what we're talking about. Sorry.
Another way that you can move murder down to voluntary manslaughter is through a heat of passion killing. And this is a killing done in the heat of passion without any time to cool off. Cooling off is one of the major issues around voluntary manslaughter, how long you can stay in the heat of passion. It's usually not weeks. It's usually instantaneous. All right, so that's it. That's all the law you really need to know to do this question, which I think is also very telling that oftentimes people feel like they cannot do a practice question because they don't have enough knowledge of the law. But you can see that to work this practice question, you don't really need to know all that much law at all.
No, I mean, honestly, you could get this from like a condensed outline of any criminal law piece of thing, book, whatever that you open up. You know, that's all you need. You don't need all the details at this point.
Yeah. So, Alison, should we switch gears and read a fact pattern?
Sure. So this is a California bar question from February 2008. California bar questions are actually great to use for your essay practice in law school, even if you're not in school in California necessarily, because they're available online for free. And they tend to be pretty focused on specific topics that your professors are also likely to test. They're not super esoteric. So we'll link to the website where you can find these questions in the show notes. But if you're looking for practice questions, these are a great place to look.
Yep. And just so you know, these questions are designed to be done in about 60 minutes, which can give you an idea of where you want to be when it comes to doing these practice questions. But the other thing I like about using these as kind of practice questions in law school is the fact patterns aren't that long. So it really makes you kind of focus in on the facts and not get distracted by a lot of other stuff that can be distracting.
Yeah, and also, interestingly enough, we have a tool on our bar exam website that you can purchase called the Brainy Bar Bank for California, or the MEE, which is the Uniform Bar Exam. Those are even shorter, and they're not available online for free. So if you want to, for some reason, practice on those, that might actually be a good tool for you to check out.
That's true. What the Brainy Bar Bank does is we've keyed everything by legal issue. So you could say, I need to practice questions on voluntary manslaughter, and it would give you questions either in California or in the MEE that are dealing with voluntary manslaughter, so you can do very focused practice. So that's something else you might be interested in.
All right, but back to this question.
We'll link to that in the show notes. All right, here's our question. Dan's neighborhood was overrun by two gangs, the Reds and the Blues. Vic, one of the Reds, tried to recruit Dan to join his gang. When Dan refused, Vic said he couldn't be responsible for Dan's safety. After threatening Dan for several weeks, Vic backed Dan into an alley, showed him a knife, and said, "Think carefully about your decision. Your deadline is coming fast." Dan was terrified. He began carrying a gun for protection. A week later, Dan saw Vic walking with his hand under his jacket. Afraid that Vic might be about to stab him, Dan shot and killed Vic. Dan was arrested and put in jail. After his arraignment on a charge of murder, an attorney was appointed to him by the court. Dan then received a visitor who identified himself as Sid, a member of the Blues. Sid said the Blues wanted to help Dan and had hired him a better lawyer. Sid said the lawyer wanted Dan to tell Sid exactly how the killing had occurred so the lawyer could help Dan. Dan told Sid that he had shot Vic to end the harassment. Dan later learned that Sid was actually a police informant who had been instructed beforehand by the police to try and get information from Dan. So your call of the questions, your two call of the questions, try that one more time. The two call of the questions are, 1, may Dan successfully move to exclude his statement to Sid under the 5th and or 6th Amendments to the United States Constitution? Discuss. And 2, can Dan be convicted of murder or of any lesser included offense? Discuss.
All right, so I'd say this is a pretty typical bar question in the criminal law sort of space. They're often combined like this.
Yes, I think that that's very true. Usually in your class, you probably are just taking a criminal law or a criminal procedure class.
Right.
But, a few things I think are typical of this in like a crim law exam. Usually somebody dies, at least one person. Always.
Pretty much always.
It's usually not as simple as an intent to kill. It's usually, a fact pattern is usually just not going to be like, he wanted him dead, so he shot him, and that's the only
There we go. Check.
There we go. Check. There's usually some sort of ambiguity about what the charge would be, and you usually need to discuss like homicide and lesser included offenses. So that is one of the things that you want to get comfortable with, is making this determination of what issues around homicides you will be discussing in a given fact pattern. And then for Crim Pro, it is oftentimes questions around what happens after somebody has been either detained or arrested. And then in a Crim Pro class where you dive a lot deeper into these issues, you also will need to talk a lot about what's excluded if something has been a violation of somebody's constitutional rights, and when can this evidence be used? When can this evidence not be used? Is there a fruit of the poisonous tree problem? I mean, it's never very simple. It all becomes very complicated. So this is a more simplistic version of some of these issues that you will likely see on a exam question, but it's a great place to start practicing because it still allows you to exercise those analytical muscles.
All right. So now we've read the question.
Yep.
Gotten a little bit of analysis on what it's basically about. So let's go through it fact by fact and talk about what's legally significant or not legally significant for each and every fact in this fact pattern.
Okay.
So number 1, the first sentence tells us Dan's neighborhood is overrun by two gangs, the Reds and the Blues. Significant or not?
Well, I mean, I think it can go to some of his fear, but this seems to be more background information and setting the stage. So not necessarily triggering its own legal issue. What do you think?
Well, I would say I disagree a little bit because I think it does go to his state of mind. And since some of the requirements around self-defense require that he have a reasonable belief, I think you could at least make the argument if he's in this more dangerous neighborhood, there's clear gang activity, he knows about it, that he might require a lower threshold trigger for something to be reasonably threatening to him in a way that might not be for somebody who's in a more, safer, more upscale type of neighborhood.
Yeah.
But I agree. I mean, I think we're basically on the same page.
Yeah. All right. The next one is that Vic, who was a Red, tried to recruit Dan to join his gang. So what about this? What is legally significant or not about this?
Well, it's showing the relationship.
Yeah.
So, just giving some context here.
Yeah. I mean, you wouldn't have any sort of self-defense argument if you just walked by a dude with his hand in his jacket. And you were like, I think he's going to kill me. That seems
certainly Dan's lawyer has a lot more to work with here if he's literally met this person, essentially been threatened by them.
Knows he's a gang member,
knows he's a gang member, knows he has a knife, most of the time, or at least some of the time with him. These are the things that are going to, go to his state of mind when he decides to draw the gun.
Yeah. So the next fact is that Dan refused to join the gang, and Vic said he couldn't be responsible for Dan's safety. I thought this was legally significant because really it's laying the foundation for the threat to Dan's safety, which can go to these ideas of self-defense or heat of passion or why he did this killing or trying to make this killing more justified.
Right. I mean, it shows, A, that his belief might be more reasonable, that this person has it in for him, and B, it could show potentially that he honestly believed subjectively that he was in danger.
Right. And then I think the next fact just adds to this because it says after threatening Dan for several weeks, Vic backs Dan into an alley, shows him a knife, and says, think carefully about your decision. Your deadline is coming fast. I saw this as more evidence of the same stuff. This is a threat to Dan's safety.
They're really piling it on.
They are. So if
you didn't notice that maybe Dan had issues with Vic and maybe Vic was a threat, I'm pretty sure by the end of the sentence, you're like, oh, maybe this guy had reason to think that this other guy was dangerous.
Yeah. This is basically the professor or the grader waving a flag in front of your face that this is a major issue that needs to be discussed because they've given you a lot of facts to go towards it.
I really need to talk about this one.
Yeah. And then Dan becomes terrified and begins carrying a gun to protect himself. And this shows he was scared and likely goes to his mental state around self-defense and heat of passion.
Yeah, absolutely. I mean, again, kind of more of the same.
Yeah. So then a week later, Dan saw Vic walking with his hand under his jacket. And this is legally significant because it's the entire reason that Dan shot him, basically.
Right. And this is going to be obviously one of the major topics that would be discussed you can imagine a trial on this going forward where, the prosecutor is going to say, well, just because he put his hand in his pocket, why did you think, that doesn't mean anything. And then you've got this entire context about, well, I thought he was reaching for a knife and he threatened to kill me. And, this is really the heart of the question is, what does it mean that his hand is in his jacket in this context? Yeah,
exactly. And then the next fact goes along to say, afraid that Vic might be about to stab him, then Dan shoots and kills Vic. Again, legally significant because this is the reason that Dan shot Vic. This is also legally significant because it shows that the shooting happened, which goes to murder because he killed him by shooting him.
Right. And here, it's interesting because, the open question really is obviously it's sort of the reason he shot him. Factually, it's the reason he shot him, but legally, is it the reason he shot him?
Right.
Did he shoot him because he thought he was threatened? Did he shoot him just because he wanted him dead? This is, again, kind of what the whole case turns on.
Yeah. And then we kind of shift gears because Dan's arrested and gets put in jail. So the fact that he's in jail is important because that goes, now we're moving into our crim pro kind of space, goes to the custodial element of interrogation. It's important that he's not, at his house. He's in jail.
Right. He's not out on bail. Right. He didn't escape and that kind of thing.
Right. And then after his arraignment on the charge of murder, he was appointed his attorney, which goes to that Sixth Amendment issue of when the right to counsel is attached. You'll remember a rule that you have to know that somebody has been arraigned, then they get a right to counsel. Dan then received a visitor who identified himself as Sid, a member of the Blues. So what did you think this started to give us information about?
Well, I mean, I think that starts to get into questions about, is that okay? Like, should he have been read his Miranda rights at that point? Like, was this person working as a police officer? Were they not working as a police officer? I mean, we're told they're not a police officer, but could they be construed as a police officer? All of these sort of issues that you're going to probably want to talk about.
Yeah, I mean, this is a great area of factual ambiguity that is often discussed around interrogations on criminal procedure exams. I've seen a lot, both in the bar space and also in the law school space, because it can get a little squishy around,
right.
Who is actually acting as a police officer, when are you responsible for, what you said to somebody? If you didn't know they were a police officer, when are you protected? And these different rights stemming from these different constitutional protections attached at different ways and can have different ramifications. So, that's one of the things that you want to keep in mind. So the fact that the visitor comes in, says he's a member of the Blues, and starts asking him questions and giving him justification is all important to these Fifth and Sixth Amendment issues. So Sid then said the Blues wanted to help Dan and had hired him a better lawyer. The first time I read this question, which was years ago, I remember being like, that is a really stupid fact. Like, who would buy that? Who would be like, oh, you guys want to hire me a better lawyer? Sweet. Like, the lawyer fairy just came down and got me a better lawyer. That's amazing.
Well, I mean, maybe in the context of oh, you shot our enemy, so we want to help you. I mean, it seems a little far-fetched, but I guess you could see it, if you're in the jail sitting around and you're like, oh my gosh, my life just got so much better. But you do, word to the wise, if you're in jail and someone comes to say they've hired you a better lawyer, you probably want to actually talk to the lawyer, not to that person.
Yeah, because then if that same person then says what Sid said, that the lawyer wanted
right, tell me everything.
Tell him everything about how the killing occurred. And Dan was like, sure. That's not a good, it's not good. You always want to be quiet. You don't want to admit to anything. But
this is not legal advice. This is only legal information.
Exactly. So again, this is whether or not this is an interrogation that he kind of prompted him, saying that he wants this lawyer wants him to tell him what happened. And then Dan tells Sid that he shot Vic to end the harassment. Which is legally significant because that's the admission, that's the confession that they would want to use in court.
Right, because that essentially is going to undercut all of his self-defense type arguments because he's undercutting an issue in those defenses, which is that he honestly had to think he was threatened. And if he admits that basically that wasn't why he shot him, then that's a serious problem for his defense.
So then Dan later learned, that Sid was actually a police informant.
Oopsies,
who had been instructed beforehand by the police to try and get information from Dan. So this again goes to the fact of who was doing this interrogation. Is an informant an agent of the police? Is it like a stand-in for a police officer? And then for these different, protections to attach, does it matter? So that's kind of where that comes. So that's all the facts. And I think by going fact by fact like this, you can see which facts relate to which issues. And although, we spent a few minutes kind of going through slowly, I think this exercise of really carefully going through the facts and analyzing what is legally significant and what are these legal issues that are triggered by these facts is something that you want to practice doing in an exam scenario, leading to a complete outline of the question. Because, if you ignore some facts, it's very possible you're going to either miss key legal analysis or you're going to miss key legal issues, both of which will sink your exam score.
Right. And one of the things I think is actually interesting about this question, which I'm not sure you see all that often, but it's something to watch out for, is so when they really piled it on and you're really thinking oh, this is definitely self-defense, slam dunk, no problem. Which you could easily write your essay like that unless you notice that what he told the informant was that he didn't do it out of self-defense, basically.
Right.
So, all these facts are really leading you almost until the very end to one very clear conclusion, and then suddenly it just gets really muddied.
Yeah. Which is why oftentimes you want to still discuss the regular murder charge first, because before you dive into imperfect self-defense or heat of passion or these other kind of alternatives to murder, I think there is an argument here that the government could make that he had an intent to kill, because he, one, clearly shot and killed Vic, and then he said in part of this little jailhouse confession that he was doing it to stop the harassment. And harassment is necessarily going to get you down to these other lesser offenses, again, depending on how you can argue both sides.
Yeah, he really should have kept quiet.
Yeah.
He had a lot of good facts. He had a lot of facts in his favor, and then he just went and messed it up.
Stop talking. Don't ever talk in jail. So let's run down kind of the answer to this question. And one of the things I really think that's interesting about this question, and one of the reasons why I wanted to raise it, was an easy mistake that people could make. I think especially early in your legal career would be to not follow the order of the questions as they're presented. So you'll notice that even though in the facts we talk about the homicide and then what happened in the jail, which makes sense, because he had to get arrested first, that the calls of the question start with his motion to exclude the statement, which happened in the jail, and then it moves to the conviction of murder. And I think it could be a rookie mistake to want to talk about the murder first, because that's where the facts were first, and then talk about the exclusion of the confession. But that is a huge mistake, because if your professor puts things in an order, or the bar examiners put things in an order, or there's really any order about anything, you really want to focus in on it and do it the way that it's presented to you.
I think that's absolutely right. And the other thing to notice is they specifically ask you in the call of the question about the Fifth and the Sixth Amendment. So not that you wouldn't necessarily discuss those anyway, but you want to be absolutely certain that you cover both of them completely.
Yeah, probably have a header about the Fifth Amendment,
yeah, exactly,
and a header for the Sixth Amendment.
I mean, I'd like to see, header number 1, Dan's motion to exclude, bullet point A, Fifth Amendment, bullet point B, Sixth Amendment.
Yeah.
Do your discussion.
Right. And then within each of these sections, then comes your IRAC. You've got to have your rule for the Fifth Amendment about Miranda warnings. You have to have a Miranda warning before a custodial interrogation with a police officer. And then you have to say, was he in custody? Well, yeah, he was in jail. Slam dunk issue. Yeah. Was he interrogated?
Don't need to talk about that one very long.
Was he interrogated? Well, yeah, they asked him questions. So, designed to elicit an incriminating response. Now, where it gets sticky is it wasn't a police officer. It was Sid, who was working for the police. And Dan didn't know that Sid was an informant working for the police. Dan was free not to talk to the informant because he didn't have to talk to anybody in jail. But he did it anyway. And so this is going to be a problem with claiming a Fifth Amendment violation, because, one of the things that they're trying to protect you from, if I remember from all my Crim Pro days, is the power differential between police when they've got you trapped somewhere. And here there's no power differential. He thinks this guy is another, informant, or he thinks the informant is just another guy in the jail, another gang member. And he was just dumb enough to rattle on and say things he shouldn't have said.
Yeah, and I think that's one of those where a lot of people are going to not quite notice that and just go instantly down the wrong path.
Yeah.
And just say, he was working on behalf of the police, therefore he qualifies as a police officer, done and done. Fifth Amendment violation.
Right.
No, it's not that simple.
Exactly. And that's why this distinction between the Fifth and the Sixth Amendment becomes so important, because when you get to the Sixth Amendment, remember that the Sixth Amendment attaches once formal charges are filed, when we know he's been arraigned and charged with murder. So that has already happened. And that means you have a right to counsel during some sort of a police interrogation. So in this case, I think it would come out that it doesn't really matter that he wasn't aware that Sid was an informant. Sid was acting on the direction and the guidance of the police officers to get answers out of him. He was really acting as an agent of the police, and you probably need a lawyer when the police are doing that.
Right, and this isn't a situation where these are just two people in jail and they happen to start talking and then one of them decides to inform on the other. Right. That could be a different factual distinction that could matter in this situation. Here, it's laid out that the police basically let him do this or told him to do this. So I think, you've got a pretty strong argument that this is a police interrogation, even though he's not technically a police officer.
Yeah.
Isn't law fun? So many distinctions you have to remember.
I know. All right, so let's move on to Dan's conviction for murder or any lesser offense. So we discussed earlier about murder being the unlawful killing of another with malice and aforethought. You would want to go through, of the 4 different theories to prove malice, what applies here. Did he have an intent to kill? Well, he pulled out a gun and shot him, so probably. Did he have an intent to commit great bodily injury? Probably. He pulled out a gun and shot him. Did he have a wanton and willful disregard for human life? Well, shooting somebody typically does show that. And this doesn't seem to be under the commission of a felony, so felony murder would not apply. So you would go through each one of these and quickly discuss, even if the analysis is similar, you want to say what theories that would be possible, but this would probably just be an intent to kill because he took out a deadly weapon and pulled the trigger. So that's not a really nuanced issue. The real meat of the issue, where we saw all those facts, are between the self-defense, imperfect self-defense, and heat of passion. So I would take each one of these individually, remembering that self-defense has to be an honest and reasonable belief that the victim is about to kill or inflict great bodily harm. And so then the question becomes, Alison, do you think that Dan's had a reasonable belief?
I would actually argue, I think you could make a strong argument he does. I know from looking at your notes, you might disagree a little bit on this. The fact was this guy was only reaching for his pocket, but there's a lot of context here, and I think you use that context to show that he legitimately thought he was under threat and felt like, he might be pulling a gun or a knife. I guess we're not really told how far away they are. That might be a fact that would have mattered, but we don't have that fact.
Yeah. I also think that if they had given a little more facts, like say he had his hand in his pocket and he saw a bulge in the jacket, or if they had given me a little bit more information about why Dan could have thought this was something that could have been very violent. I think this fact pattern doesn't give you enough facts to really do an in-depth analysis. But if this was especially a law school exam, I would raise these issues, Alison, that you're raising of we don't know. Is this an exterior pocket? Does he just have his hands in his pocket? Is he reaching for something? Could this be seen as reasonable? I think there's ambiguity around it. And as the person who is doing this essay, you would want to argue both sides and really lean into that ambiguity to collect all of those points.
Right. Dan's real problem here is he doesn't have an honest belief. It seems like, he didn't really actually think he was threatened at that moment. He just did it because he was annoyed with the guy bothering him.
Right. Which was his whoopsies. Don't confess to things in jail. But
I do think sometimes people also make the mistake of only talking about that and ignoring the reasonable part. And that's a mistake because you're leaving points on the table, even if you ultimately decide that he did not have an honest belief.
Right. And, of course, you're going to try and be a good defense lawyer and argue both sides. And the important thing here with looking at self-defense and then the possibility of imperfect self-defense is that he could have had an honest and unreasonable belief of this impending harm. So this will not get you out of murder, but it downgrades it to manslaughter. But he still has to honestly believe that the self-defense was necessary. So, your counter argument is going to be what he said in the jail, but then, of course, maybe it's going to be well, I say lots of things in jail. I don't want to sound like a weak person who could get scared at anything. Who knows, right? But you want to make arguments on both sides to show whether or not there was an honest and unreasonable belief. And if it's unreasonable yet honest, he's going to get voluntary manslaughter. It's not going to be self-defense.
Right. And he could also say, well, yeah, sure. I kind of shot him because he was annoying me, but I was also afraid of him. He did reach for his pocket. I honestly believed he might be doing something bad.
Right.
But again, now we're basically making up facts that aren't there, which you typically want to avoid.
Yep. Then I think the heat of passion argument is something you can raise, but I don't think it's going to win here because you need it for a heat of passion for the killing to be done in the time that you're under the heat of passion, which means no cooling off period. And, when there had been about a week from the time when he was really being threatened and, and told that his time is running out and things like that, that's probably a little too long. Heat of passion is usually, you walk in and you find your spouse in bed with somebody else. And then in a heat of passion, you hurt somebody or, those kinds of fact patterns, which is much more immediate. If you've had time to kind of contemplate your actions and go out and buy a gun and start carrying a gun, that's typically not going to be heat of passion.
Yeah, exactly. I mean, for there, you're really looking for a scenario where it's something happened at that moment and someone reacted without thinking, and that pretty clearly is not the situation here.
Yeah. I know that with this question, there are some people who think it's important to raise first-degree murder as well, going back to just our general discussion of homicide, because he was carrying a gun, that this could have been premeditated and deliberate. Is buying a gun premeditation? Maybe, but we don't have a lot of facts that he was walking around with the intent to kill Dan, more that he was fearing his own safety. So I don't think that was a major issue because they didn't give you a lot of facts about that. But if somebody was thinking about that, I think that it's not necessarily wrong. And if you had plenty of time on an exam and you wanted to throw that in and say that like you don't have enough information or this is what that argument could look like, I don't think that would be a bad thing. They just didn't give us a lot of facts relating to this.
Yeah, absolutely. I mean, I think as always, it's going to be a question of getting the most bang for your buck. There are probably tons of things you could talk about here, but you've got to really focus in on the ones that are most important, that you've been given the most information to work with.
Yeah. So our goal with this exercise was to really just kind of try and give you another example of what we mean when we talk about focusing on the facts and doing quality issue spotting and really writing an answer that is driven by the facts and the fact pattern and not just by all the rules that you have in your head. And we also hope that you could see that if you are putting off practicing because you don't know the law, that just a small review of legal issues can really help you go ahead and do this analysis, because practicing this analysis, practicing working with the facts is going to help this law be more meaningful to you. And then you are going to be able to be a much better exam taker.
Right, because, you know, if you miss the fact that a police informant is not necessarily equivalent to a police officer in a practice test, you're much less likely to miss it on a final.
Yep, and this fact pattern shows up all the time. So people love to test on it. All right. Well,
absolutely.
I think with that, we're out of time. If you enjoyed this episode of the Law School Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it. And be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@lawschooltoolbox.com or allison@lawschooltoolbox.com, or you can always contact us via our website contact form at lawschooltoolbox.com. Thanks for listening, and we'll talk soon. Good luck with your exam prep.